seated. All right, let's see if we can clear some people out of here on the 8:30 docket. Looking for anyone who's here who got a protection order in the last 2 weeks, is here for the first hearing and you were not able to get service on the other side yet. Okay. Pardon?
Filed April 1st.
I don't know about what you mean by filed date. Are you the petitioner?
No.
Then right there it takes you out of what we're talking about. Is it someone here who's a petitioner but no longer seeking their protection order? Are you here as a respondent and you do not see the other side present? All right, let's start at the back. Come on up, sir. What's your name? Number 2.
Either.
Natalie Wilcox?
You have an attorney, sir?
Yes. He
Who's
was
your
supposed to be
attorney?
Chance Fuel.
No. He'll probably be here.
All right, we'll come back to it.
Okay. So sit again.
Yeah, go ahead and have a seat. There was someone else here, sir. Come on up.
She just came in.
She came in, all right. Over here, someone had their hand up? No, I'm looking for respondents that the other side has not made it. If so, come on up. I don't know.
Oh, okay.
Are you a respondent in this matter or the petitioner?
The petitioner.
No, I'm talking just to respondents. If you're... So is there any respondents here that they do not see the other side? All right. Petitioners that are here, well, let me see. Let me get some of the attorney matters out of the way. You guys probably have other courtrooms going. Mr. Diedrichson, I think you were here first.
Well, yes,
And
I
Mr.
was.
Woods on
And
that
Mr.
side
Wood.
as well.
I was just looking for just a moment. Are you guys come forward?
Well, if you need a moment, if not, go ahead.
Some moments.
We'll take your matter.
Mr. Davis filed a notice of appearance yesterday, Your Honor.
Oh, he did?
Yes, so
Okay,
I
so,
haven't seen him or talked to him.
all right, we'll come back to that.
Thank you.
All right. Matter, petitioner is present, but you do not see the other side and you've got service. Okay, come on up. If you're coming up, tell me your name. Tamara Clark?
Yes.
Do you know what number you are on?
I think-
Number 6,
yeah.
there it is. All right. First, there was no service, then it was reissued,
Correct,
and you have service this time?
yes.
And
And I
you have-
turned it in yesterday morning. They told me it would be added to the file yesterday, by the end of yesterday.
Hasn't made the file yet.
And I took a photo of the form of the
Hang on,
service.
they'll look it up.
Yeah.
Okay.
It was filed yesterday.
Okay. I'll authorize the order. The theory is if they're not here to contest, they don't have an objection.
Okay.
things on your petition and the order entered really don't match up, and I'm trying to figure out what should be granted. So this Erica is your mother?
Erica's my daughter and her mother, and I'm filing it on behalf of Zao Wise, who's a minor. And I have legal guardianship of Zao Wise.
And in that legal guardianship, what sort of visitation does she have, if any?
She was granted, I believe it was Wednesday evening for 2 hours and I think Sunday afternoon for 2 hours with supervision, which she's not ever really exercised.
You're going to need to go into that case and modify that if you're wishing to prevent that.
Okay,
I'm going to grant it here, but
Okay.
this isn't a place to modify.
okay,
So I'm going to put a limitation on how long. So
okay,
this order with regards, that's in effect, so that's the proper place to
Oh, I
be
see.
cleaning that up.
okay,
This was, I don't mean you came to the wrong place, but this is kind of a short-term
okay,
emergency fix.
okay. So I need to make an amendment to the
Yes.
parenting plan?
I don't know if it's, did it come out of state of Oregon? You
No,
used
no,
the
it's
term guardian.
Washington.
Is it a non-parental custody action?
Correct.
Okay, you said guardianship, that's something
Oh, I
different.
apologize, yeah.
They use that term in Oregon.
Oh, okay. I think it was granted in like 2007 here in Clark County.
And Beck, are you filling in the table here, or are you going to wait?
And are we, so is Zaya part of that order? Or she need to be filled in under the child?
Yes, it just gets filled in here.
So I'll be putting her in and
Yeah.
the child.
Thank you.
Okay, you can step over here and
Thank
I'll
you.
finish the paperwork. Mr. Wood,
Your Honor, I have a witness coming to attend if the court allows it. I told him to be here at 9 o'clock.
we're not, this isn't a place for witnesses, it's declarations, affidavits,
Well, and
or
I'll-
special sets for witnesses.
Well, here's the situation, Your Honor. There's a material,
Well, let him make his argument, Mr. Diedrichsen.
thank you. Your Honor, in the materials we received on Friday, which includes some police reports, in one of the police reports, there's an allegation that my client was by the petitioner's residence on March 5th at approximately 10:30. I met with this witness. I have a declaration of this witness, but we were given, deadlines to provide materials. This witness would testify that this witness, at the time they're alleging in the police reports that my client was near the petitioner's residence, that he was with her casino from about 9:30 approximately till past midnight in the police report. It's anecdotal to the main part of that police report, but it's still relevant and material, because if they're gonna start arguing that he violated the order, we've had two such, well, that report, one, another one. So I think we could not provide a declaration on 4/2, which was our deadline, because we
Well,
didn't
then
get that
the
material.
request is to seek a continuance to
Well, I mean,
add
again,
that.
court, I mean, if that's what you wanna do, I mean, again, that's.
We're not taking testimony from
We're
the
not taking
witness.
testimony today, so then.
Why don't you gentlemen come on
Okay,
up?
well, and that's where, okay.
So are you just mainly here seeking the right to take the deposition?
Well, you're here to defend the case. You've got my motion, you've read it. I can, obviously, like I know you always do, we're asking one for a motion to depose, for the reason I stated in my, in my declaration, as well as pointing out to my client's declaration regarding defending the allegations that were brought in this action by the petitioner. Again, I'm making argument right now. I think we provided substantial objective evidence to call into question many of the statements under oath in the petitioner's petition. Again, I don't have to go into great detail. I know it's a busy docket. So yes, I think a deposition of petitioner is appropriate and the right thing to do. This is about a search for the truth at the end of the day. And what we have in this case, as I just talked about, we have multiple allegations, involving my client violating this order after the fact. Now, luckily, I have a witness, coming in that can refute that and provide testimony to the court. I have a declaration already prepared.
Let's knock off the moment. We're kind of jumping around.
Okay.
Focus on the request for a deposition.
Yes, I think it's appropriate. It's material and relevant to the decision-making process here. Ultimately, this is a search for the truth. And
Is there a criminal case pending at this time?
my understanding is that there's an investigation going, and I think they're in their own declaration, they talk about making a report to the Milwaukee Police Department. It's my understanding there is an active investigation, and
All right, that was
involving.
gonna be my first question. You say there's no criminal.
Nothing's
no-
been filed
Okay,
criminally.
would you agree with Mr. Wood saying that there's an active investigation?
I believe that's the truth, Your Honor.
Question I have, are we gonna include law enforcement process doing depositions in this civil matter with the pending potential criminal?
And I understand, and as the court knows, my client has an absolute right to remain silent. He's waived that right, and he's made a very clear declaration as to the allegations alleged. So, again, I know it's a difficult decision for the court to make. It's certainly, for the reasons we've stated, we want the deposition of petitioner. If the court doesn't grant it, then I guess we're moving on to dealing with the case at bar today. And that's where, again, I understand that we were given deadlines, and I understand that this is not necessarily a place to do sworn testimony. At the same time, there's an allegation they provided that we couldn't respond to until after we knew what they were alleging. Again, what I mean by that is they provided two police reports, as I recall. One of them makes an anecdotal reference to my client on March 5th, 2019, approximately 10:30 p.m., being near her home, which would have been a criminal violation of the order. I have a witness coming in. I also, and again, here we go. Here's something else I can do. And again, I'm not trying to bushwhack anyone. I'm trying to do my job and diligently defend the case. Here's a copy of the declaration from Darlene Nodine, who you can have. I mean, you may not have, or if you don't want to take it, that's fine too.
No, I'll take it.
Okay.
I'll
all
take
right.
it. Are you,
Okay. I mean, again, I'm not trying to bushwhack anyone. I'm trying to do my job and defend this case. If the court doesn't want to allow it, then I would ask the court not to consider that allegation in the report for March 5th and deal with everything else.
Well, the protection order is previously granted.
on the 24th of
The temporary.
February.
The temporary, right.
Okay, well,
I mean, we're here to determine a permanent order for a year or more. She got granted a temporary order because it was a one-way process where she made all these allegations. And again, as you know, and I know you've read it, because you're very good about that, we provide extensive declaration and objective evidence that go to the weight of her testimony. And again, I don't want to jump ahead with the court.
let me hear from Mr. Diedrich, and we're just focusing at this point on the deposition.
Okay, thank you.
request.
Thank you, Your Honor. First of all, I'd like to know what case exactly Mr. Woods is here to defend. There are rape allegations. There's also, as Mr. Woods says, there are it's possible that Mr. Schalk violated the temporary order of protection. That isn't before the court. There's been nothing filed there. We're really just looking, excuse me, at the petition for the order of protection. And as far as the deposition goes, Mr. Schalk, the respondent, has provided something like 100 pages of response. There's something like a 6 or 7 page declaration, and then there's dozens and dozens of pages of text, which he would claim would tend to show that this petition should not be granted. If he's put all that stuff down on paper and it's before the court, the first question is, why do they need a deposition? They've
Well,
got plenty right
The flip side
here.
of it is having her explain the text messages she is sending immediately after this event. Someone who is a victim of rape typically would not make the comments and be engaged in the conversations the way that those text messages show.
Okay.
So it's an explanation, I assume, of
Well,
hearing her
there's
version of why that is.
actually 2 events that would be the predicate for the petition. The first is the rape in Milwaukee, alleged rape, okay, in Milwaukee, Oregon, that happened on the 4th of February. That's what the text, or that's what Mr. Schalk says the texts are all about. There was also an event on the 24th of February, after which the petitioner brought this case, which really precipitated that, and that's that what happened there, and they both agree on this, is that Mr. Schalk appeared at petitioner's house with a bunch of roses, and petitioner says he tried to push his way into the house, and Mr. Schalk said he didn't. I think for this purpose, we don't have the he said, she said from the first incidents, from the alleged sexual assault. We have something that we know where and we know when, and that's agreed. So what happened right there? She says he tried to push his way into the house. Now, we do have an additional deposition from a friend of Ms. Sanchez's named Guillermo Fregoso Segura. And attached to that are screenshots of his of texts which Mr. Schalk sent to Mr. Fregoso Segura, saying things like, you know, I know you're in there. I see your car, so I know you're in there. And then he follows up with a text that says, I'm going to get you, basically. I know you're undocumented. I'm going to turn you in, meaning turn you into to immigration. So he was there. He was mad. He was hot. And the question is, did he push his way in or not? Was he unwelcome or not? Ms. Sanchez says, yeah, he was unwelcome, and he did push his way in. So that is really what the court ought to be focusing on here, and that everybody has seemingly overlooked, or not everybody, but I mean, that's easy to overlook when the big allegation is a he said, she said with these texts, which...
Well, but the big allegation he said, she said, has dramatic implications, and at this point, his gun rights have even been limited because of that. I saw in the file.
Well, his gun rights would be limited at this point anyway, even if there weren't the first allegation. If she said, he pushed his way into my house, I don't like it, and I'm afraid, she'd get
No, not necessarily. So, last chance for argument on the deposition issue. We're keep sliding away from that.
Okay, what I would say is, first of all, as I said, the deposition is unnecessary. Secondly, depositions, as I read the case law in DVPOs, are typically granted when there is some bigger matter at stake. And that could be incarceration, which isn't at stake here. You can't put him in jail. custody of the kids, or even possession of property, if they combined households. We don't have any rights here. The only right that Mr. Schalk is trying to protect is his ability to basically go and see Ms. Sanchez, which she doesn't want anyway. So really, the stakes here are not so big. The court should determine it on the record, on the paper record, and we don't need to go through the fandango of a deposition, which I would suggest is not really for the purpose of this proceeding. It's more to get around rape shield laws.
Rape
And-
shield, I'm not sure I understand. how
Well,
it can-
Well, they want the benefit of I'm sorry, I'll
Yeah,
stop.
just hang on.
Well, he's the criminal defense attorney. He
No, I
wants-
know what the rape shield law is, but.
Well, what I'm saying is that this
No
being a
one's-
civil proceeding, he is, Mr. Wood and Mr. Schalk
He's
are,
not gonna be allowed in the civil proceeding, if I grant it, to ask her about her other sexual activity and experiences in life. The questions, I think, would be focused on the text messages that she's sending during this time the alleged rape is alleged to have occurred, do not fit with someone who feels they had just been violated.
well, I think you've just answered the question there is, you're saying on their surface, they don't, these matters, or these texts don't appear to support her initial claim. And if that's the case, why does he need more explanation? If he's saying there's inconsistencies, they appear on the written record. So why the
Let me give
deposition?
Missy Wood a chance to
Your Honor, again, I'll be brief. They can't have it both ways. It's not a big deal, so you shouldn't order that. Oh, wait, now we're gonna be getting around rape shield laws. No, we all recognize there's implications, but the issues that I am trying to address were brought up in their petition. That is what I'm trying to defend. Now, also, what is also I wanna make sure is very clear. We have two allegations. Again, one in the police report, one that was brought by his client the morning of the hearing about violation of this temporary order. Again, you have a declaration from one alibi witness addressing the allegation on 311. As I mentioned to the court, there's a declaration I've gotten, and another witness is on the way, to provide an alibi for the 355. There is criminal implications with this order. If you grant this order, there is a finding that my client has predicated domestic violence, which we argue is not accurate. When you look at everything we submit objectively, when you look at that, a deposition is appropriate. This is about a search for the truth, isn't it?
Here's what I'm gonna do in this. I am gonna allow the deposition. They are seeking to get answers to the allegations in the petition, but in the meantime, I'm continuing the temporary order. We're gonna set a deadline to get the deposition taken, then be back on the final order.
Can I make a suggestion, Your Honor?
I'm open.
Why don't we have something like depositions on written questions, limited to 15 questions, and
No.
take it from there?
I've done those before as a practicing attorney. It just doesn't work well. However,
Go ahead.
the issue is the allegations in the petition.
Yeah.
You had concern about the rape shield law, and I understand that, Mr. Diedrichsen. It's not appropriate. It doesn't matter about what her sexual experience has been with other people on other days.
I will happily, and we'll even do one better. My client will not be present for the deposition. That's perfectly
Well,
fine.
that was gonna be a
We're fine with that. We're not,
Yeah.
I am not here to do anything inappropriate, rude, or unnecessary. Okay, I have to balance, again, I always try and be extremely professional in everything that I do, and I'm trying to balance it, but I still have to do my job to the best of my ability and belief. And I'll be as professional as I can. My client won't be there. Now, on a deadline, I'm of course open to that, sir, and I'm sure Mr. Davis and I can come up with dates that work. But what I don't want is a deadline where, we couldn't come up with dates that work for everyone. I'm willing to do it on a weekend, in an evening, so we can make it
Yeah,
work.
and if necessary, even though I'm filling in for Commissioner Scheinberg today, this is unique enough, and I'm involved at this point. I'll have you gentlemen, if necessary, come back to me.
Okay, so are we gonna schedule a special set before you to hear the matter in totality, or just for the
Not,
deposition?
hang on, you're a step ahead.
Yes, sir.
So first, what's the amount of time do you think reasonable to get the deposition taken care of? and then obviously.
To accommodate schedules, I want to say 4 weeks, because, I mean, again, we have to line up, as you know, we have to line up the folks and Mr. Dietrich's calendar and his client's calendar and my calendar. My client won't be involved. Like I said, I can do it evenings and weekends too. I'm open to do that, but there are some limitations I have.
In the meantime, the temporary order is going to be continued.
No objection to that.
I think I'll put this to follow up on one of my Friday civil dockets.
Yes, sir.
What do I have in May? Tracy? Tracy can be out with our calendar.
Yes, sir.
fast.
Thank you, sir.
No, you wouldn't expect me to do that today.
I didn't, but that's okay.
May 10th or 31st?
I don't want to keep, I mean, well, what's your, so
I
what's your
prefer
schedule?
May 10. I believe I have something scheduled for the 31st.
Let me look at May
of
10th,
December.
Your Honor. Let's shoot for May 10th. I don't have anything available that day. I will work diligently with counsel, and Mr. Dietrich and I can sure we can get it. Now, again, if there's issues with his client's availability or something else, we'll address it then. Thank you, Your Honor. Thank you, counsel.
Pardon me, Mr. Wood,
Sir,
is Mr. Schalk here today?
yes,
So he's aware that the restraining order's been
yeah,
accepted.
and he's aware.
He'll
And
be,
He's aware.
we'll have him up here and sign on
Yes,
this
sir.
as well. And this, again, you said it was all the way back to February 20,
It was filed the 24th of February.
the temporary order,
Yeah.
February 28th. it looks
Oh,
like.
excuse me.
I just see it here now. All right, I'll pass this down, Mr. Diedrichson, you can sign behalf of your client.
Okay.
Mr. Wood, I'm gonna have you and both your client, then no
That-
service will have to occur. He'll
Right,
get
no,
his
that's
copy
fine, Your
now.
Honor. We can bring him here. I'll have Mr. Dietrich sign first, and then I'll bring my client up here on the record.
Okay. Can
You
I
want
borrow
that?
your
Of
pen?
course you can.
Thank you.
You're welcome.
I thought I saw Mr. Davis come in, Ms. Foster.
He did, he's speaking to his client, Your Honor.
All right.
He may be seeking a continuance, but when we come to file it.
All right.
Thank you.
Thank you, sir. Shaw, come forward, sir. Okay, you are signing right there. Dating today is the 16th, if I recall correctly. And again, as the judge has informed you, and I'm sure you heard, this temporary order is still in effect. Any alleged, or any violation would result in potentially criminal penalty and could result in contempt too. So, okay,
Okay.
thank you.
All right,
Why don't you go sit back down,
If he
Steve?
needs a certified copy, he'll have to go downstairs.
It's okay, we don't need to.
Natalie and Jay Wilcox matter.
Can I ask one quick question? Just so, that 5/10 court date, is that to check on, is that gonna be our time for hearing on the
If
matter?
you're ready.
Okay, that's what I wanted to make sure.
If not, checking in, just kind of
Okay,
keep track of
thank you,
it.
sir.
Okay,
Thank
so
you.
it's tracking or
If you got the
dispositive?
deposition ready and you, yes, so
Okay.
potentially the final argument on it.
All right, thank you, Your Honor.
James LeBlanc with Beatty Hatch for Natalie Wilcox. We're just moving the strike, Your Honor. We moved all this to family court now and
Okay.
have updated
We'll
temporary
enter an
orders.
order dismissing this action.
Thank you.
Well taken care of, well taken care of. As I tell you.
The interpreter matter, number 19.
But these are the validity.
Good morning, Your Honor. My name is Vanarandam, court certified Cambodian interpreter, having been sworn, Your Honor.
And what language?
Cambodian.
Cambodia, okay, we'll get the file up here. And her name is,
តែឈ្មោះដែរ
Nươn Chươn.
នឿនឈឿន
and is the respondent here
ជនអ្នកចង់ចោតមកទីនេះទេ I have not seen him, Your Honor.
Her.
Vendia Kawaha.
ឈ្មោះ
Chua Vanida Kill.
Vanida Kill. I did not see her.
All right, let me see. We have the service on the order.
តុលាការបានទទួលនៅកដាស់ស្នាមនឹងបានហៅទៅឲ្យគាត់ហើយ
He's not here to object, we'll
គាត់
grant the
បានមក
order.
តុលាការអនុញ្ញាតហើយណា Thank you, Your Honor.
Hang tight, we'll process the paperwork.
នេះគឺកដាស់ស្នាម
And he's vacated the house.
ហើយគាត់នឹងចេញពីផ្ទះហើយនៅ
Trên còn là trái ngayពី8.
She did, Your Honor. She left on the 8th.
Okay. All right, I'll have you step over here and they'll finish the order.
Thank you, Your Honor.
Veronica Garcia Morales. Number one. Oh, okay. Ms. Garcia Morales, I guess we're waiting for an interpreter, so we'll have to come back when they get here. We'll recall it. Ms. Foster, Mr. Davis, are we ready on yours? This is number 17.
Good morning, Your Honor.
Good morning, Your Honor.
Your Honor, am I requesting a continuance on this case? I was just retained Friday, actually, when I was in trial. I was in trial again yesterday. We did receive a bunch of new materials. They were emailed to my client at some point Friday. I don't know, Friday late, I
Are
think it
you
was.
objecting to a continuation of the temporary order staying in place until the next week?
Not until next week, yeah, so it'll continue until next Tuesday.
Okay. Ms.
We've
Foster, any
arranged,
objection?
No, I have no objection.
All right.
we've arranged some two phone visits with father in the meantime.
I can read that, those conditions, if that's okay. 2 phone visits, up to 10 minutes. Mom will initiate the calls. Mom has the ability to monitor but not interfere, and she has the discretion to hang up the phone if it sounds like it's going any kind of inappropriate behavior, Your Honor.
Okay.
And I'll have my materials filed by Friday like usual. And argue on Tuesday.
And we're just going over to next week?
Yes, you're on the 23rd. I believe that, is that, you're still your docket, Your Honor?
No, I'm just filling in for Commissioner Scheinberg, so
Okay.
she'll be back. I'm assuming she's back. I'm not doing this next week, so I'm not sure who's,
Why not?
because I will be in trial, or I would love to come back and visit with you.
Will Commissioner Scheinberg get our materials, Your Honor, or should we resend them?
We'll forward them.
Okay.
I'll make it a point to do that. Mr. Davis, is your client here today?
He is, Your Honor.
All right, so we'll need to have him come up and sign, that way he doesn't have to get service.
Once he's done, we'll step over there.
The order really doesn't have all the conditions. There's a place other if you want to write this
The phone calls
in
thing? Sure.
best you can, and then have everyone sign it, then give it back to the clerk.
Okay.
They're going to write in on other, the visitation.
Thank you, Your Honor.
Thank you.
Thank you.
Number 7.
Morning.
Yes. what time?
Ms. Smith,
Seven,
number 7,
seven,
yes.
yes.
Smith Hess, yes.
And you're appearing on behalf of who?
Ms. Hess, this is a courtesy appearance, Your Honor. I represent Ms. Hess on a unrelated,
And you are,
Ms. Hess.
okay, so it's the respondent.
Yes.
Michelle Smith?
Ms. Hess had court this morning, and she notified me her name was on this docket as well, unbeknownst to me. So
we ran up here.
She had court in district court?
Yes, she had her arraignment this morning.
Similar, related to this?
That is completely unrelated. This was a
Okay.
driving while suspended, actually was what she was downstairs for. So we ran up here. She reports, I have limited information, Your Honor. She reports she wasn't served with any
Has not
paperwork.
yet.
No, so.
Okay, I called cases earlier that there wasn't any service.
I came in late.
It's good to be in court on time. Because at that point, I could have just dismissed. So,
And just further information, I believe, and I'm assuming that this came out of a criminal charge that was filed in Superior Court, which has since been dismissed. Just letting the court know that. That's how I originally was
course.
retained on this.
right,
So.
different burdens of proof.
Correct. But I think that's what this is related to. So,
Maybe.
again, courtesy appearance today. I have not been retained on this, but I'm familiar with the situation. So.
Probably is, sounds like potential allegations of assault too.
Yes, that was, and it was subsequently dismissed, and it has not been refiled in district court, and that was about 3 weeks ago.
Okay, well, what we need to do is obtain service, so, I'll, 2 weeks, and you're gonna still need to get service.
Okay.
Do you need personal service on her, or you're not appearing?
I'm just on a courtesy appearance at this point, so personal service on her would be the request
All
this
right.
time.
So this hearing's gonna be continued for 2 weeks.
He's saying in 2 weeks, and then you're going to get copies of what that date will be. Okay. You weren't. I mean, you weren't served, so you would have no idea. So it's not, you didn't do anything wrong. Okay.
If you had a set of all the papers, we could take care of it now, but I'm assuming you don't.
So if he hadn't showed up, there was no proof of service, there's no proof that you got notified or something. But there isn't.
All right, you'll step over here, sign this, and at this point, we're back on 4:30 at 8:30. Be on time.
He's right, their standard of proof is lesser, but she still has to show that there's no sort of danger to her.
Do I need to serve her with the previous documents or just?
Yes. Because that's what, the one that has all the allegations in it that she's here to defend against.
Thank you.
The one, actually, hang on 1 second. Why don't you come on back? I'm not requiring this all. If you want to take a look, I mean, and I'm not meaning to imply you should agree, but I could potentially. If we could have you sit here, take a look at the court file, read the petition. You're seeking to have an order just restraining her from being around you. If you're in agreement, and I'm not meaning to suggest you should be, then we might be able to just process it today.
Because you don't have any problem.
No, I don't care. I mean, I could agree to.
Are you no longer living in this?
Unless it's not incriminating
Yes,
to me.
exactly, yeah. That's
Right.
the thing.
No,
Because I
it's not,
really
it's not,
don't care to have any.
it's not incriminating at all. In fact, that way you're not making any statements one way or the other.
That was our concern, we talked about outside, so that sounds like a good idea.
So, what's the status of living in the same residence?
We don't live in the same residence and we never have.
Oh, you did?
She was a
Okay.
friend of a person that did live there, so she was
All right.
never part of it.
What we can do you want to So all it is you would be restrained from going around her residence, her place of employment, and then staying 300 feet away from her.
That's completely fine. I have no issue with that.
Let's
All
take a
right.
look at it.
Okay.
Let's do that order, then people don't have to come back, you don't have to worry about the service. That is, if you could, like I say, I'm not trying to convince you or talk you into it, I'm just, if you wanna be back in 2 weeks,
I don't think she wants to miss any more work, because
Yeah,
we've got some
no,
stuff going
I
on
don't.
then
downstairs.
that's fine, let's, yeah. So give me a order.
Thank you, appreciate that. Okay, don't care.
Just the regular order issue.
You don't like her.
After,
I don't like that either, so. She would kind of be around. Sometimes people try to contact. You don't run with any circle of friends. There's no. They were just roommates. She's they don't live together anymore. I thought she was kind of nobody to take her case. My boss was like, he's been doing this forever. He's just like, ugh. I kind of gotta go with him. Like, I was fine with it, but he tells you that you're kind of like, I probably should do what the old man says. But like, you guys haven't worked at the same place. There's nothing being. I just want to make sure that she can't like entrap you. Okay. You don't see her out. Just talk. Well, if you do, turn around and go away. If something does happen, by chance, just make sure you document.
let me go over these orally, that way if there's any
Thank you.
objection.
Yep.
Since we're doing this kind of under a unique scenario.
Sure.
You're restraining him from causing physical harm, bodily injury, assault, sexual assault, molesting, harassing, or threatening, or stalking the petitioner. Again, you're not admitting any of these allegations. Respondent is restrained from following or keeping her under surveillance. Restrained from having contact with her, that's direct, email, phone. You're excluded from her residence and workplace. And that residence is at the 2200 Northeast Bridge Creek Avenue.
That's fine.
Apartment 41. All right, they'll step over here, they'll go over this, they have a little more they need to fill in. You get your copy, and you do not have to be back in.
All right, thank you.
Thank you.
Thank you. Tamara Clark, Erica Gunlatch matter. Tamara Clark. Are you Ms. Clark? All right, we'll strike, not present. You do an order of dismissal.
Yeah, what number is that?
Number 6.
Thank you. Oh, we did number 6.
Pardon?
We did number 6.
We did, oh, I just didn't mark it off, sorry. Kelly Wagoner. Bigley John matter. Kelly Wagner, Bigley John. All right, number 8, we'll strike. Here's the order on 22.
Do they need to come up?
Sure, what's the name on, I'll call it. Michelle Alba. We're continuing so you can get service. I would note you were late to court. It could have been just outright dismissed and you had to start over. Be on time next time.
Yes, Your Honor.
They'll process you.
Thank you.
So I need on
So it's
number
continued
8.
for 2 weeks, okay? Okay. We're sending it back to the 30th for Alba?
Yes, 2
2
weeks. I didn't fill it.
That's okay.
They're not present yet, so I need to do an order of dismissal with the strike.
So you're gonna go ahead and sign here and date. Number 8. Sorry, you need to go downstairs and get your copies. You'll have to start on with this one too. Okay. And the original. Yeah, so just sit down there, they'll call your name. Okay, thank you.
Fill in the caption. Yvette McGee, Antonio Crosley. All right, I'll do an order dismissing. Well, that last order of dismissal, can I see it back for a second? I think I might have missed something. I did. Fixed it. This is on number 9. We're gonna come back to 10. Number 11, Laura Cuddy, Daniel Powell. Come on up here, sir. I assume you're Daniel Powell?
I am.
Have you seen Laura Cuddy here?
I believe she left.
Okay, she was here earlier?
Yeah, I saw her when I first came in. She was sitting in here and then up and left.
How long ago was that you saw her leave?
I got here at about 8:40, 8:45, probably right around then.
All right. And you haven't seen her come back in?
No.
That was,
I was half expecting that.
all right.
Just
She's
from hearsay
not wanting
through
to go
reference.
forward with it, I'm gonna Sign an order of dismissal. All right, dismissed.
Thank you, sir.
Thank you. Karen McAllister, Christopher Armand,
If you want to come, otherwise it's dismissed. You can always.
all right, who are you?
Karen McAllister.
And you
I'm her
are,
daughter, Patricia Sellers.
and have you seen Christopher here today?
No.
And you received that service on him? All
Yeah.
right, I'll grant the order.
Do I sign here?
Yeah, I have to fill it in. It'll be a
okay.
minute.
Thank you.
There's a bunch of papers here. If you'd like, if it's easier
Okay.
if I have your seat
thank you.
while I do this. Sorry, Becca.
When you're done with the first page, go ahead and hand it down.
Okay.
Off the line.
Did you share the residence with Christopher?
Yes, he
But-
lived in my home.
Okay, he's out now, though.
Yeah, he's out.
Okay.
He tore my house up, so.
And what's the zip code at your house?
98660.
Michelle Hensey, Jerika Russell, you're Michelle?
Yes.
Have you seen the other individual here, Jerika?
No, she's not. She's typing.
And the two children are residing with you?
Yes, they're mine.
Okay. She's not related to them?
No.
Okay. Do you have the, you'll fill in the children block,
All children?
the two that were listed in the original petition.
Okay, thank you.
At the time when this came forward, she's not been residing at your residence.
No, she got served and she took her stuff. My mom was given a key
Okay,
so she could get her
prior
bed.
to this, she was living in your residence? Okay,
Yes.
then I'm gonna mark it a little differently as a shared residence. Is it Menlo
Yes,
Drive?
yes, MENLO.
Thank you. They'll finish processing here. Amelia Sapphire? Sean Richer? Are you Sean? Come on up. Let me take a moment and review the file. All right, Mr. Richer, your question I have for you, are you contesting her request to have a no-contact order between the two of you?
Yes.
All right, go ahead and give me your explanation, why.
I have a daughter who has friends in that apartment complex. I mean, I have no opposed to like not seeing her at her job or anything, but like the apartment complex has numerous friends of my daughter. I didn't threaten anybody. I don't want that to sound like a record.
Okay, so if and I'm just paraphrasing what I think I heard, so correct me if it's wrong. What I'm kind of gathering, you have no objection to a no-contact order between the two of you, but you just have concern about how close you can come to her residence because you have other business at that apartment complex.
Yeah.
Are you aware of other friends that he has in that complex?
Not me, my daughter. I don't have
Okay,
friends there.
his daughter.
I guess with the entire order, I kind of wanted to amend it. I don't have a problem with him talking to me. My problem is with him coming to my residence. The entire fight that started this was a very public one in the parking lot of my apartment complex, and my manager told me that if I was not doing something legal about it, I would be evicted. I can't be evicted over him making threats in a parking lot.
All right, well, so let's go back. Any objection to him coming to the apartment complex, I assume to take your daughter there, pick your daughter
Yeah,
up?
that's it. I mean, I have no objection to
How,
me not going to her
the other
residence.
units that you would be going to, how close are they to her
They're not
unit?
close. She lives like three,
More
four
than-
buildings away.
Okay, so more than 300 feet.
Yeah.
All right. With that, let me get a copy of an order. I can,
Is
you
this
won't,
gonna be no contact, like I can't text her or speak to her?
well, that's what I'm gonna pin down as I fill out the order.
Yeah, I'm open to him still being able to contact me. I just can't. I want
just
to
doesn't
be
want me
his
at her
friend. I can't have this
So no
ruin my life.
face-to-face is what you're saying.
Yeah.
Let me tell you the concern. I'm not gonna deny you your request, but the concern I have, when people have that level of contact, it grows. Part of the problem is that you're potentially setting him up for a criminal charge, because you invite him over, things are going well, you're talking nice on text and emails, you agree to meet at a McDonald's or somewhere. If you go, sir, just be aware, you will be committing a criminal
Is
act.
it possible for us to still be able to have contact, but for him to not be
Like, she can
able to come to
house, but
my
I can't go to her
apartment?
Well, then you don't need an order. I mean, that's just, stop,
Sorry.
that's just common sense and decency. When I come to your house, I shouldn't be assaulting you, I shouldn't be threatening you. But the problem is, it's hard to restrict that if you're allowed to have contact. So you either are gonna have contact or you're not gonna have contact. It's hard, you have to think of law enforcement officer being able to enforce this. And how do they know if the two of you are together? Well, his words coming out of his mouth that they can't hear, because they're down the street or approach, don't know what's being said. They can't hear it, so how do they enforce that? So it's either we have an order in effect that says the two of you cannot come together, or we dismiss it. It doesn't mean, but what we don't want is a month from now you coming back in here. I mean, you can if you're entitled to. I'm not trying to dissuade you. Then you drop that one, then a month later you come in for another one, and we just go that route. So what are you wishing to have me do today? You wish to have me drop this, or you wish to still be requesting it? There's no right or wrong answer. I'm not trying to suggest one way or the other.
Honestly, I just don't know because I can't risk things like my residence over not being able to tell him, hey, you can't come here, and having him actually listen to that. If you went through any of the
Well,
texts,
that's
most of them
I might be able to.
end with me telling him not to come over and him coming over anyways, which is how we keep ending up back together. I say, don't come over, it's not going to change anything, and then there's a knock at my door in 5 minutes.
Well, you need to direct me what your request is. If you want a moment to think about it, I'll let you sit down. We'll come back to it in a case or two.
Then I'm going to go through with the no contact order.
Okay. Just out of fairness, because of the reservation, I'm not saying do this, it won't be fair then for you to communicate and invite him over, because you're inviting him to commit a criminal act. He's the one that will go to jail if that should occur, not you, even though you might have instigated it. Do you understand what
Will
I'm
I
saying?
still be able, can you keep, like, text communication?
Let's see what I can do that's unusual. Yes. And the zip code there on St. John's Road?
98661.
661?
98661, yes.
I know he may know, but I don't know. I can't hear you when you're talking with the papers in front of you.
98661.
One, thank you. All right, the way I've modified follow this order, it's in-person contact that's being prohibited. And you have to stay 300 feet from her apartment. All right, both of you can step over here, finish with the clerk, get your copies.
Did you want the child included in there?
No, that's fine. No.
No child?
Right. Willow Taylor. And Brian Edgar. Why don't you come around? Yeah. Right there will be fine. Brian Edgar, have you, all right. You've not seen him today? All right, it's time. And you have service, it looks like?
Yeah.
All right, so enter the order.
Just gonna head downstairs and find the mail, okay?
Oh, you brought Mr. Hensley? Okay. I'm not sure where you want to put him in the jury box? I mean, that's not till 10, it'll be a little bit till we call it, or if you want to hold up in the little conference room right there. We'll call you in a few minutes when we're ready. over here and they'll finish you.
Thank you.
Willow Taylor?
That's her.
Oh, right, I just did mark that. Vanessa Bennett? Pardon?
No, that would.
Kanza Bennett and Anthony Antolic?
Wait for them to clear. Thanks. Yeah.
All right, which of you is Ms. Bennett?
I'm Kansas Bennett.
Okay, and have you seen Anthony here?
No, I
today?
have not.
All right, let's see. So at this point, you don't have service.
Correct.
It was never served?
That's what it looks like I found. Return of not found, and then here's another one I'm looking at.
Because they did not find him there at the address there on 7th Avenue. Anyway, the one that's there in Vancouver, we took the order out to the sheriff's office.
Right, and the sheriff's office said service was attempted at the address provided. We are informed that he no longer resides there. We used an alternate address, but were advised that he no longer resided there either. No other addresses were available.
Okay. Because they said they would return the paperwork or let us know if it was not served, and we never heard.
I can't tell you why they didn't let you know. I can tell you they filed the document. So I can extend it if you're still wishing to attempt to get service on it.
Can you get it without service? I mean, what's we haven't seen this man for 2 years, and all of a sudden he shows up and gives us an address that's 5 blocks from us.
I understand. Well,
So we're
let me
just,
take a look at the petition, see what,
so we're
this
just
is-
wondering, because he never got served the other one from the other judge during the divorce, because we had no idea where he was. All of a sudden he shows up and,
In checking the court file, I see there is a return of service from Christine Cloner. Do you see that in the file?
right, that's the,
File on the 15th?
no, that one's not in the
Okay,
file.
so that didn't make the file. It appears they did serve him. Christine, 18 years or older, served him at 707 West 13th, 98660.
Okay, what was the date of service?
On the 12th, Friday the 12th, 9:20. And he was served with the petition, the temporary order, and the notice of hearing.
Yes.
From the Clark County Sheriff's Office.
okay.
It's number 5 in Liberty. I can have somebody print it and bring it if we need to recall.
No, here's the problem. What I'm gonna do is I'm gonna do an order extending your temporary order for 1 week. Let me explain why 1 week. He hasn't had adequate notice. So I'm gonna set it over to next week's docket to see if he's filed any response or he's making any objection.
Okay. So do we need to come back?
Yes,
Okay,
if you want the ongoing order.
okay.
By then, the proof of service will have made the file.
And if he doesn't show up then again, then we get the
Then you'll
year.
get the year long.
Okay.
I understand what you're getting at. It's kind of, but she's raising a point, does he have to be served this order? I'm gonna suggest that it be attempted to and given to the sheriff's office. This order continuing for next week. Actually, I should set it for 2 weeks then. I'm sorry,
If you try, this man will run and hide. I mean, he's hid from us for 2 years.
that's fine. I'm gonna have them attempt to do so.
Okay.
It's called due process under our state and national constitution. So that's the 30th, then,
Yeah, you wanna change that in the order?
yeah. Here, I screwed this one, can you just give me an arm? All right, they'll finish processing you. Kirk Flanagan, are you present? Denise Flanagan? Eduardo Bermudez? Okay, do you know the Flanagans as well?
I saw them leaving this morning, yes, should be here.
Okay, I'll just hold off, we need to get to it soon because we have transport here. So hopefully they're on their way or theirs will be dismissed. They're,
Yeah, but that's the house almost at the same time, I just walked by. They should be here.
Nicole Curry? Gary McAndrew? Have you seen Gary here today?
I have not. I did not. I wasn't able to actually serve him myself. There's a,
That's one we'll be looking to
Yeah.
see. It doesn't, there's no proof of service in here, so you haven't got him served yet. Are you wishing to have the order reissued for another 2 weeks?
yes, please. I have a no contact with him already till 2025, so, and I'm not sure where he is. I've done everything I
Okay.
can to try to locate him.
You're in, maybe in, I'm not trying to dissuade you from this. If you have a no contact order with him in another matter, why are you seeking?
It needs to include my children, and we needed more
Okay.
specifications.
At this point, you're gonna have to get service on him if you want it entered, and we just can't continue. So are you doing any efforts to figure out where he's at so he can be served?
I have, yeah. I've contacted a few people that were mutual friends a while ago, and then I had somebody contact him who was in contact, not by phone, but by Facebook messaging, and she wasn't able to find out where he was directly.
Do you think he's in this area?
I'm aware that he is. I got a call from the sheriff's office on Sunday evening, that there was a disturbance involving him, so.
Did they, if they were involved, they frequently then on their contact reports get addresses. Did they get an address for him?
I do not know.
All right, if you arrange service through them, they'll at least be able to look at that.
Okay,
At this point, I'll continue it for another 2 weeks.
thank you.
Shelley Johnson, number 21. Todd Johnson, we'll dismiss. Do we ever get the interpreter for number 1? Spanish interpreter?
I think the volunteer attorney Riley just went downstairs to
Okay. Yeah, are they here?
I heard back from them, they're not able to get us one here.
Okay. All right, can someone step in, let custody know we'll take the Hensley matter? We're gonna go forward on number 5. Mr. Bermudez, come on up and stand over here. Can you hand me this file?
You want up here?
Yeah, he can stand right here.
Hey, Your Honor, can I bring a chair up there?
That'd be fine.
I don't want to pop and tick.
Yeah, that's fine. You can just come right up here. The custody officer will stand in between the two of you.
Hey, I'm well aware of my Fifth Amendment rights.
Okay.
As an accommodation for my disability, may I explain my disability prior to the commencement of this?
No.
Fair enough.
And the only reason I say, Mr. Hensley, no, you and I have been dealing with each other for a number of years now.
But I don't know if Mr. Bermudez is the only person here, or if the Flanagans are here as well.
The Flanagans are not here. Their actions are going to be dismissed because they chose not to come.
Fair enough.
So let me take a look here at the file.
I do have the orders. As an accommodation for my disability, I would like it read out loud, please. The entirety of it, everything that he wrote.
You were served a copy of it.
Yes, but as I said, I have a difficult time reading and writing, especially when I'm triggered and incarcerated. Now, I've been here since the 31st of March, and they have failed to provide me any medication at this point, so I need it read out loud. And if I do have a vocal outburst, sir, you understand that that is not my intent. Fuck you.
I'm going to go through this, Mr. Hensley. Because we have a large document, I'm not going to read parts that are not pertaining, that are on the
Now,
paperwork.
if Mr. Bermudez testifies, is he going to be placed under oath?
Mr. Hensley, I'll conduct the
I'm
hearing.
asking, I'm just trying to.
We're not there yet.
Trying to manage my expectations.
I'm not sure yet.
Respect, sir, thank you.
Okay, so with Mr. Bermudez saying that he's a victim of unlawful harassment, that he knows you by being neighbors. His name, Eduardo Bermudez, am I pronouncing that right?
Yes, sir.
Okay. That he's over the age of 18 and that he's a parent or guardian of 4 children, and he lists their names.
But one of them's 18.
Correct. So so technically that's an adult.
Thank you.
That the respondent is 18 years of age or older, that meaning you are 18 or over, that you live in Clark County. Or you did not leave the county because of this conduct. That the respondent lives in Clark County, the conduct took place in Clark County. One of the things he's saying is on March 29th, 2019, that you said, he, Mark Hensley, said he wants to smear the road with my Mexican body. He stated he wants to kill me and would really like to get his hands on me. During this occurrence, he threatened that he would kill me several times and states that at this point, he has nothing else to lose. He states that we do really think do we really think a no trespassing and no contact order will stop him, Mark, from putting a bullet through my chest? That these were made through social media on YouTube. And then he's asked to describe the incidents. He states, stating on or about June 2015, Mark began threatening to kill me and scream at me and my family from across the street on a regular basis. My children
Fuck you. I apologize, Your Honor.
have had to live in fear of being in our front yard because of slander. He screams at me and my family. That this makes them feel like a prisoner in their house, afraid to allow their children to play outside. That you have threatened to purchase a gun and shoot him through the chest. That he is aware that you have passed impending felony charges. He says he is an imminent threat to my neighbors that you are an imminent threat to neighbors who have also been threatened by Mark with violence. It then lists a number of apparently case reports, police numbers, where they've responded and made reports.
Excellent. Did he provide those?
Yes.
Will I get a copy of those?
You got a copy right
I
there.
didn't get a copy of those reports that he.
No, I didn't either.
Okay,
They're
so
not
he
part
didn't
of this
provide those.
file.
He just gave you numbers.
He provided the numbers.
Respect. Thank you, Your Honor.
And then it says, ask the question is, have they ever requested or obtained a protection order from the other person, and a restraining order, civil protection order, criminal no contact order? And the answer was yes, no trespassing order, Ridgefield Police Department about 1 year ago.
I think it was more than a year ago, but I'm aware.
Okay. He states there is no other litigation between the two of you.
There will be.
Correct, that's what it states. He's requesting hearing of a no contact order between you and his family, that you're prohibited from keeping them under surveillance. You're precluded from going to their residence or workplace.
Just for clarification, Your Honor, it's not him and his family, it's him and his minor children, not his wife Pamela Bermudez, correct? She's not listed?
She is not listed.
Excellent.
That you are to stay away 1,000 feet from the residence and workplace.
I live 50 feet away from him.
I understand that.
Thank you, Your Honor.
That's their request.
Understood.
That you surrender any firearms that you may have, and that this order would last for the maximum duration of a year, and that they're asking for a temporary protection for the 14 days to get to
That's
today's
already
hearing.
happened while I was in jail. Yes, Your Honor.
All right, and then it shows that you were served these documents.
By Officer Ullman in the Clark County Jail.
Yes, Evie Ullman, Deputy Ullman. On April 3rd, so adequate notice.
Yes, Your Honor.
So are you contesting this, Mr. Hensley?
Without a doubt, Your Honor.
And, all right, there is already a no contact order entered in the criminal case.
With Mr. Kirk Flanagan, correct. Now, he didn't show up, so you told me that you wanted me to discuss.
No, he's not here, so those matters with he and I believe it was another
Denise Flanagan.
Those will be dismissed.
But the state has imposed a separate one.
That's a separate matter. These are civil matters. That's a criminal matter.
Understood, but you told me when I was in front of you on the 4th that I needed to go to this particular hearing because the state has ordered me not to be within 1,000 feet of my own residence. And you said to discuss the matter at that point. I didn't know that I was going to be in front of you again, but here we are.
It's just coincidence. I'm covering for the normal judicial officer.
Respect. But if I do bail out, I of course will want to return to my home, which would be within 1,000 feet of a man that lives 10 feet away from me.
Okay. You're mixing things up a little bit, so let's back up.
Respect.
The criminal orders, no contact orders that are in effect will not be altered by anything we do this morning.
So I will wind up being homeless if I bail out.
What we do here this morning will not alter or affect those. I'm not sitting here as a criminal judge.
Then I will
I'm sitting
consult my
here as a
attorney on that criminal matter, and I'll stop discussing that at this point.
That would be the way to
Respect. Thank you,
handle
sir.
it. So then, what we are discussing on this matter is with regards to Mr. Bermudez.
I will keep it strictly to dealing with Mr. Bermudez and his minor children.
Go ahead.
I have the floor.
You have the floor.
Mr. Bermudez and I initially started out as friends in August of 2014 when he moved in. I went over and introduced myself and helped him fix his sprinkler system.
Okay. I'm not too concerned about that past.
I'm just letting you know the past relationship because he said I started screaming at him in June of 2015, correct?
Correct.
So I met the man in August of 14.
But the allegations that bring us here are these current ones. He didn't outline those others, so I can't really act on them.
Will you please place me under oath and place Mr. Bermudez under oath because I would like the penalties of perjury to apply.
I have no problem placing you under oath. Do you swear, you don't need to stand, Mr. Hensley, and you don't even have to raise your hand. Do you swear affirm the testimony you're about to give in this matter be the whole and complete truth?
Yes, I do, Your Honor.
Go ahead and proceed.
I have never threatened Mr. Bermudez. I do not own a firearm. I did purchase a Ruger 22 back in, I believe, the summer of 2008 because I had to euthanize a pot-belly pig that was attacking my wife and children on a consistent basis. I could not muster the fortitude to execute the pig, so I put it on Craigslist, gave the pig away, and then gave the weapon to my neighbor, Steve Rizzini. He lives on 189th Street in Ridgefield. So I do not own a weapon. I have never attempted to purchase a weapon, nor do I want to own a firearm. So his statements are completely inaccurate. Now, there might be some confusion in this, which I can explain as well, but on the evening of the 29th, I believe was the evening that we have in question, Your Honor is aware that I suffer with Tourette's, I contend with Tourette's and PTSD. The combination of the two, when they're exacerbated, is overwhelming for me to deal with. I don't have telephone service, but all phones are required to be able to dial 911. I have 2 iPhone 6s, as Your Honor is aware, because I constantly place videos on YouTube. Nonetheless, those phones can dial 911, so I called 911, got connected with the crisis services. After a long conversation, multiple conversations with the crisis services, they decided to send out a mobile crisis team. That consists of a DMHP, a designated mental health care professional, and a peer counselor, right? Somebody that has either gone through drugs or been crazy, and they came out clean the other side, so now they're a peer coach or peer counselor, if that makes sense.
We're really not addressing the issue.
This is when he said I threatened to kill him, Your Honor.
No, it's not.
Yes, it is.
Okay, hang on, sir.
So nonetheless, they came out to my house, and I was conversing with them on my front porch. 2 people came out on the porch in the house beside me, Mr. Flanagan's house, and to me they looked like teenagers. They had baseball caps on. I couldn't identify who they were, and I said, is one of you Kirk? And a gentleman came swinging around and said, no, it's Eddie, motherfucker. And I said, Eddie, I can't handle you right now. Just stop. "What are you gonna do, pussy?" I said, "Eddie, you really need to stop. I can't handle this right now," right? And then Mr. Flanagan started in, and I'm going to drop my typical bravado, and I might be a little vulnerable at this point, right? But like schoolyard bullies, they began
I'm
heckling.
gonna have you pause.
Yes, Your Honor.
The case with the Flanagans is being
No,
dismissed.
this is Eddie that I'm discussing, right? So I'm sitting there, and Eddie is continuing to pick at me, calling me a pussy, calling me a faggot, saying, "Come and get me."
When you say Eddie, because it has, I don't know people.
This
so
is Eddie.
Okay.
Eduardo, yes, sir.
All right,
I'm
I just
only
wanted to make
discussing
sure
this gentleman.
that we were talking about the same
Yes.
person. All right, I
So-
didn't make that connection.
Yes. So he continued on and continued on, and I was sitting there smoking a cigarette because the nicotine has many beneficial effects with Tourette's. There's a lot of scientific studies for Your Honor to look at it if you would like to research that. But nonetheless, I sat there and I took as much as I could. Now, I've been in cognitive therapy for years, right? So when it was getting overwhelming, I stood up and I engaged the DMHP, right? And I sat there and I was like, eye to eye, like, you got me, and I had tears rolling down my face because I wanted to go over there and eat that man's lunch, right? And I just sat there and I was like, you got me, I got you got me, right? And Eddie was just like, "Come on, pussy, what do you got? Come on, pussy," right? And I engaged with that DMHP, and then I looked at the peer counselor. I said, "I need you to call 911 now. Call 911, right? Now, I wanted Eduardo and Mr. Flanagan both arrested for disorderly conduct, because if that DMHP had not been there, Your Honor, there would have been an assault, right? My PTSD was raging. Now, Eddie has a history of assaulting me in the past, and I didn't even fight back, right? But this time, there were two of them coming at me, and they were mine, Your Honor. Anyway, the DMHP, or the peer counselor, instead of calling the police, called an ambulance for me. And I went inside, and I took a bath waiting for an ambulance to show up. My care provider locked everybody out because she didn't want to deal with this shit anymore. Then, fuck you! I apologize, Your Honor. And then the ambulance came, loaded me up, and took me to Legacy Salmon Creek. They put me on a 5-day psychiatric hold, and then released me, I think, 4 hours later, after I was seen by a state social worker, I believe she was. I got a prescription for nicotine patches because I didn't have any money for cigarettes. And I think my care provider came out at some point in that evening and picked up my service animal, Walter, because he's getting old and he wasn't doing well at the hospital. And then they ordered me a cab and sent me home. Now, as I said, Mr. Bermudez has a history of assaulting me, shoving me, to be quite honest, 3 different times until I was out in the middle of the road. And then James Bauman came over and shoved me from behind and said, "What do you want, both of us to kick your ass?" I said, "Knock it off, boys, I'll take you off at the knees." They then had me arrested for harassment, for using the idiom, "I'll take you off at the knees." Mr. Bermudez got me convicted of harassment, so he's currently using the same dialogue, same storyline, to try to get a restraining order against me now. What was successful for him in the past, I doubt will be successful now, especially if he's under oath. I would like you to know that I've never spoken to Mr. Bermudez without it being recorded either by myself or Mr. Bermudez. Mr. Bermudez has 6 video cameras on the eve of his home, all aimed at me, right? So I don't speak to any of my neighbors or Mr. Bermudez without that. Now, I've been in contact with Chief John Brooks of the Ridgefield Police Department, and I told him that we've had several occurrences within the last month.
Mr. Hensley, I'm going to have you wrap up your argument on
Several occurrences within the last month. Eddie Bermudez has extensive exculpatory evidence that I want him released, He refused to do so. I had sent Mr. Bermudez an email asking him to do so personally, and he told me to fuck off. Now, I have that email correspondence, but I don't have it with me. Now, that being said, I would like to stop talking. I would like Mr. Bermudez to be placed under oath, and my care provider, Ms. Kathleen Megan Ryan, is here and I would like her to serve as a witness for either me or Mr. Bermudez, her option.
Okay.
Thank you.
We're not taking testimony other than parties here today.
She's right there.
I understand that. The way these hearings are set up are to be done with other parties on affidavits and declarations.
Respect.
Sir, I'll get you sworn in. Do you swear affirm the testimony you're about to give in this matter be the whole and complete truth?
Absolutely.
If you want to go ahead and tell me why you think you're entitled to this anti-harassment order, go ahead.
I'm a prisoner in my own home. My children, my wife, are all prisoners in their own home. From the yelling, screaming, the YouTube videos slandering myself, they're named after us, my entire neighborhood. Why we're here today is because he threatened to purchase a gun and kill me through the protective order.
And this was on YouTube.
This is a YouTube video. This is why we're here today. None of this other stuff, I don't care about anything that he's saying right now. There's nothing else that.
Eddie stole $5,000 with my stuff. That's why he doesn't care.
he
I'll
didn't
shut up. I'll
interrupt.
shut up. He's a thief on top of it.
God damn it!
Sorry.
I want this to stop.
He wants me to stop having Tourette's. Fuck you, Eddie. And that was not Tourette's, Your Honor.
Then I can hold you in contempt.
I apologize. I won't do it again.
But you're helping build his case when you do that.
This man has a history of assaulting me and stealing
All
my...
right, stop, Mr.
Done.
Hensley. I gave you the
Done.
chance.
Sorry, Your Honor.
Then stop saying done even. Go ahead, sir.
I want this to end. This is something that we can't live with. I can't let my children outside without him constantly accosting them, getting them to try and get me to come outside. I do not want a confrontation with Mr. Hensley. I do not want to talk to Mr. Hensley. I do not want emails from Mr. Hensley. I do not want my children to have any contact with Mr. Hensley because of the constant harassment. It's harassment. It's screaming in the middle of the night. It's phone calls.
I don't even have a working phone.
I don't think I'm talking to him. I was telling you.
Go ahead.
So there's phone calls in the middle of the night, planning to blow up the Clark County courthouse that my kids are witnessing.
Good God.
I have video of that. Like,
Please.
on my phone. There's videos threatening to blow up the courthouse. There's screaming in the middle of the night. There is a series of threats with physical violence that I'm not okay with.
And you brought proof or evidence to this, and you're under oath, by the way, Eddie.
I'm not speaking to you.
Don't respond to him, sir.
a copy of this hearing, correct?
You are.
And I'm allowed to place that hearing on YouTube?
I'm not giving you legal advice. You have the ability to.
Thank you, Your Honor. YouTube.
All right, on this matter, what I am doing is I am issuing the order for protection, harassment. I'm finding that Mr. Hensley was personally served of this request, that he is present. Sir, one of the things I need to do, your child that's 18 years of age, you are no longer able to seek this on their behalf. They'll have to do it on their own.
Understood.
But I am issuing it with you and the other 3 children.
The 3 minors.
Pardon?
The 3 minors.
Yes. And that Mr. Hensley is not allowed to have contact with you or those minors, that he's not allowed to keep you under surveillance, that he must stay away by 1,000 feet
Really? 1,000 feet?
of your place of residence. It's already in effect in the criminal
I
case
get
as
that,
well.
but you know, once I get that overturned, now, I just want you to know you're really.
Once you get that overturned, feel free to come in here and seek a modification.
Thank you, but so I would just like to say, I understand that you're limiting my civil liberties.
I'm trying to put my ruling on the record right
Thank you,
now.
and then I can talk. Thank you, Your Honor.
I'm going to prohibit you from possessing or obtaining firearms at this time.
Okay.
Your Honor,
Yes.
it's up to my parents, the 18-year-old lives with me.
Yeah.
Can she be considered to be under the restraining order?
But she's not a petitioner in this matter. Yes, but she's going to need to bring her action.
Okay.
Pardon?
On the last line, he's able to list the adults in his claim.
See what they allowed on the state form.
I would object. I believe that anybody that's a legal adult has to petition the state on
Hang
their own.
on, Mr. Hensley.
Respect, Your Honor. I'm gonna make you YouTube famous.
I think you've discussed me on YouTube before. I didn't
Not you,
really see
Your
what
Honor.
fame.
That's
Pardon?
not what I wasn't saying that to you. I was saying that to this gentleman right beside me, this officer here.
Okay, that's not going. I'm going to require that 18-year-old, but he's required to stay 1,000 feet from the residence.
I understand, thank you.
Now, am I still allowed to speak to Eddie while we're in court in your presence?
Well, at this point, there's no necessity.
Well,
to.
there is.
No, there's not.
Well, I'm going to litigate against Eddie, and he needs to be aware of this because he
Then
has
he'll
$5,000
be-
worth of my stuff that I do not want him to
He
sell.
will be aware of it when you serve
I don't
him.
want him to sell it in the meantime.
On the Flanagan matters.
Yes.
I need orders dismissing those.
I would like to discuss this restraining order so I have proper clarification with you, Your Honor, before I leave.
Go ahead.
So from what I understand, Eddie is allowed to surveil me, but I'm not allowed to surveil Eddie, correct?
You are not allowed to keep him under surveillance.
But he is allowed to keep me under surveillance, correct?
That's not an issue I was asked to resolve today.
But his 6 cameras aimed at my residence, he is allowed to continue to surveil my residence. Is that accurate?
I am not addressing that issue today, so I'm not
Fair enough.
restraining it or permitting it.
So my civil liberties are limited to the fact that, and to the point that I'm not even allowed to return to my residence. So if I do get out of jail, will you have a civil standby that will take probably a couple hours for me to clear out enough of my possessions, camping gear, survival gear and such, that I can try to live successfully as a disabled man on the streets? You understand, Your Honor, why Eddie has 0 tolerance for Tourette's, right? Which is a bias, which is a prejudice, and Eddie is a bigot. And the court accepts that fact, that you have ordered me to take my Tourette's onto the streets, shouting, "Fuck you, and I will kill you," in a public park, right? Now, in the past, there's been a restraining order preventing me from going to my house, and I violated it. I drove home to my care provider in tears. I said, "I need medication. I need a friend." I went upstairs and took a bath. Mr. Bermudez utilized those cameras on his house to notify the authorities that I went home to get medication and take a bath. The Ridgefield police showed up and arrested me for that. I don't want that to happen again. I need to get my stuff, I need to get medication, and Mr. Bermudez is a fucking bigot, is a bigot. YouTube famous, Eddie. I'm a United States Army veteran, honorably discharged, Your Honor. I'm a pacifist. I was in the medical corps. I have saved countless lives, several of those being officers in the local community, right? Remember the cop that got blown up with a bomb at Wells Fargo? Or the other officer that took a shotgun to the face in Banks? Yeah, I was in on both of those personally. Eddie probably hasn't done anything with his life. But he's tearing mine down. I'll see you in court, Eddie. YouTube famous, sir.
Your Honor, the notice of possession regarding firearms is provided by the PA's office or their attorneys. We do not have them downstairs,
that's
not able to get it.
It's part of the criminal case.
Thank you. Are you finished with the Flanagan files?
Yes.
Your Honor, may I be dismissed?
In one moment, there's going to be a document for you.
What do you sign?
In signing it, Mr. Hensley, you do not agree with it. It's just acknowledging you were present.
You told me that when I bail out, I need to come in and see somebody, and probably not even you, to have this thing reviewed, correct?
Correct.
If I need, because I don't ever need to talk to Eddie again in my life, but I do need to go home.
Right here, go ahead. You want him to sign the dismissals?
Now, I do need more clarification. I'm allowed to use Eddie's and his children's name on my YouTube videos. I
am not giving you legal advice about this. The only thing that's in front of me is their request
So
for the
if it
no
doesn't state it in the
contact
no contact order, I can do it. That's all I needed to know. YouTube famous. Down to the child. Thank you, ma'am. I didn't start this war, but I'm going to finish it.
I'm gonna give you a copy. Hold on.
Thank you.
More need a chair.
No, sir, I don't. And Your Honor, they told me my next court hearing was on the 9th, but paperwork you gave me said I had an omnibus hearing on the 3rd. Will you please explain to me what an omnibus hearing is?
It's where your defense attorney and the state will exchange discovery and take positions on such as alibi, things of that nature, outlining their case.
If the state does not have evidence to proceed to trial, do they notify you of that at that point?
I'm not going to get into the criminal matter. I have a full courtroom. that's
Respect,
still
I'll talk to
going.
Mr. Fisk.
Yes.
Thank you, ma'am. You done to him? Thank you.
You can step over here, sir. I think we have the interpreter here. So let's go on Veronica Garcia Morales. Pablo Hernandez Cruz. Have you seen him here
¿Usted lo ha
today?
visto aquí hoy, señor? No, Your Honor, he's not here.
All right. We were not able to get service. Well, here's another one.
No pudimos hacerle la notificación. I did serve him, Your Honor.
Okay, we'll need to look. Have you filed the proof of
¿Usted
service?
presentó la prueba de servicio de notificación aquí al tribunal?
When did you do
Yes, Your
that?
Honor. ¿Cuándo hizo esto? And I do have a copy of it here,
When
Your
did you
Honor.
file it with
¿Cuándo
the
lo
court?
presentó ante el tribunal, señora? I don't recall, Your Honor. It was on the 19th.
19th of what?
¿De qué mes? March, Your Honor.
Well, I have one filed on the 28th
Tengo
of
uno que
March that
presentó
says
en
there
el
was
mayo
no
28
service.
donde dice que no se presentó ningún servicio. más notificación.
Here's a return of service on, again, on
Porque
the
aquí
28th.
en el 28 otra vez se habla acerca de la notificación.
That you mailed by,
En marzo 20.
pass up the one that you think
¿Me
shows
puede
you
pasar,
have
por favor,
service.
la hoja para ver cuál es la que usted dice que sí lo sirvió? La notificación. Lo recibió su esposa. His wife received it.
Was there an order allowing you to
Había
use
una
service by
orden donde
mail?
usted le permitían hacer notificación por correo.
We file and,
Yes, Your Honor.
all right. There it is.
Aquí está.
All right.
Muy bien.
I will
Voy a
grant the order.
concederle la orden. Thank you, Your Honor.
You can return those to her. They're in the file.
Se puede retornar esto.
Let me take a look at the petition here.
Van a incluir ambos menores
With children.
con niños, sí.
Your address is
Su dirección
7302
es
Northeast 16th.
7302 noreste 13. Yes, Your Honor.
And apartment 4,
El apartamento 4. Yes, Your Honor. For clarification, Your Honor, you did say northeast 16th or 13th?
Yes.
16th, I apologize. Thank you, Your Honor.
assist you in
Muy bien,
finishing
ahí le
here.
van a ayudar para terminar el asunto. Thank you, Your Honor.
Thank you. We'll come back to the phone ones. Anna Yashenko, Max Narchuk. You're Anna?
Yeah.
Have you seen Max here? Have you seen Max here?
No, I haven't.
And just looking to see if service, have you been able to get service on him yet?
Yeah.
Did you file proof of that service with the court?
How do you do that?
Well, it'd be an affidavit declaration of service. Whoever served him. Okay, so it's not been turned into the court. Pass that over here. Okay, that's what I'm trying to, yeah. All right, we'll file this. He's not present, we take it that he's not objecting, I'll enter the order. All right, I've signed the order. We'll finish with you over here. Thank you.
Thank you.
Lynette Hilton. Derek Hilton. We'll do an order of dismissal on number 2. Jeffrey Halstead, Sheila Peterson. Do an order of dismissal, number 6. Anna Marie Barheit. Come on up. Dwayne Brown. You've not seen him here today? And do you know if we have service on him?
We do. Officer Russell served him the day that I got the paperwork.
He's not filed, or did he give to you a proof of service?
He didn't. He just texted me and told me that he had served him.
Officer Russell is with what agency?
Vancouver Police Department.
So you're saying on April 5th?
Let me check my exact text. April 5th at 3:26 p.m. is when he texted me and told me that he had been served.
All right. Becca, when you have a chance, can you look this one up?
Yeah.
One moment. If it's not been filed, normally that would happen immediately. We'd have it in the file.
Right. Well, I thought the officer was supposed to do that. That's.
He's the one who would fill it out, would either cause it to be filed or give it back to you filed.
Yeah, he didn't give it back to me, and he'd been to my house 3 times with returning some of my property. But yeah, Officer Russell served him April 5th. What number are you on?
This is number 7 on the 10 o'clock docket. Looking for a return of service.
The last thing filed was the temporary order on April 5th, so I don't have anything from the sheriff's office.
What I'm going to do then is I'm going to reissue the order for 2 weeks. You need to get a hold of Officer Brown.
Russell.
And get that from him or have him do another one. It needs to get filed
Will I have to come back here?
in 2 weeks.
Okay. Only thing is that I lost my job because of him, and I'm supposed to start a new one on Monday.
Okay? I have to, what the law requires is
Sure, no,
I
I
have to
definitely
approve
get
to
that.
see that there was the adequate notice given to Mr. Brown.
Okay. Okay, so 2 weeks would be
The 30th.
the 30th of May?
No, April.
Oh, of April, I mean? Okay.
What I don't need to mark is typically, if you don't get this served upon him, actually, I think I'm going to mark that, never mind.
So does he have to be reserved, or can Officer Russell just?
The issue is, at this point, if you didn't reserve him, I think you're okay. Because he's not here, he's defaulted, so he wouldn't know about if I issued the full one for a year, which you would get served upon him. It's a little bit gray. The best thing would be, yes, but if you don't, what'll happen with that proof of service in the file from April 5th, the court will grant the full one. So, if you,
Okay.
it's kind of a fuzzy thing. The best thing to do is attempt to, but if not, you'll get an order on April 5th. The question would be if there was a violation of it now, could they charge him criminally if you didn't get him served this? That'd be a questionable
Because
area.
now we don't know where he's camping
Right.
out at all,
I'm not,
and
right. I
his son
understand.
doesn't even know where he's at right now.
Main thing is get Officer Russell to do that declaration, proof of service, get it in the court file, and then the court will be able to issue the one-year order. Tammy Boyce. And it's number 8. Shadez Grant. All right, we have all sorts of people. We're gonna eliminate, who is Tammy Boyce? Why are the other people up here?
This is her father.
Okay, you're not parties, you're welcome to stay, I'll have you have a seat back there. And you are Mr. Grant? And you are?
His mother, Rochelle Emer.
And how old is Mr.
He's
Grant?
14.
All right, you can stay up here. So,
D. Stewart, YWCA.
all right, and your relation to the case?
She is the reason for the case.
Okay, I haven't seen the file, so you guys can stand here. All right, I need,
We don't have a file for this one. We'll have to have somebody bring it up.
for some reason they didn't pull a file, I can call it up electronically.
Judge, do you want the actual file?
No, by the time you guys get up here, I'll have it up.
Okay. Your Honor. It's because the names are the minors
Oh, okay.
that we weren't able to locate the file.
All right, so you're Teagan? All right, and Shadez? Shadez, okay. Let me take a moment and review the file. question, are you objecting to their request for an order?
Yes, I am.
All right, go ahead and outline to me your thoughts.
I've been dealing with this whole thing since it happened back in February, and my son has never encountered any type of situation like this, ever. He got into his first fight at school because of this incident, which got him suspended. He's been out of school. Kids are going around saying that the story keeps changing, and his story to her story doesn't really make sense at all. Teachers at the school also are aware that they've been hearing that the story has changed from what it says there to something far worse than what is being stated that happened. I don't know exactly what's going on between them other than, I don't know what happened, there's some kind of fallout or something, but this is just, I don't like how my son's being slandered. He is not that type of kid at all. He's not even allowed to date, and he knows that. And I'm very involved with him, and I know everything that goes on with him. We're close, and I just do not see him doing what is said in there at all.
Either side, if you have anything you'd like to say. I mean, what we have is the allegation that allegedly occurred by the stairway. That's outlined here. One side saying it happened, and another side saying it didn't.
Right. I have no reason to believe that my daughter would lie about this. This is under investigation. She's had to, we have her in counseling. She's had to do a forensic medical examination because of this. I think she was naive as to what was going to happen, because at that particular time, there was nobody in the hallways or anything. She just left to go to the restroom, and then that's what happened. They do have video of them in the hallway together, but I don't think that they have the actual.
The spot where it occurred was
Yeah.
not captured on video.
That is correct, but they do have footage of them in the hallway at that time. My biggest concern is that the school has stated that they're going to change his schedule and make it so they don't have any passing times, and as you can tell by the messages back and forth between the principal, they haven't done a very good job of making that happen. He has shown up in her classrooms when he's supposed to be on the alternate side of this building or wherever his classes were. And it's just, it's a very difficult experience for her to be constantly seeing this person.
Do you have any idea where law enforcement is in their decisions?
I know that she just did the medical examination yesterday, and the advocate told us that I know that they've gone to the school a couple times to talk to the principal, but I don't know where they are. The Detective Phelps, but I don't know where they are necessarily in the process.
What is Mr. Grant's current situation in school? Is
He can't go to school because there's a restraining order. He's not allowed to be within 300 feet of her.
Right.
But
you said he was suspended as
Yes.
well for the fight.
She sent a 9th grader to the
Let
school
me
to beat
ask
him
my
up,
question.
and so that was a
Stop.
suspension.
I'm asking a question. I want just the question answered. If this was lifted, what's the status of his suspension? Would he be back in school the next day?
He's not suspended, he just can't go because she has a restraining
You're
order.
missing the question. Please listen. You have indicated he was suspended.
And he's been back to
Okay,
school.
that's what I'm trying to find out. So it's just this,
Mhm.
this protection order that's
Yes.
keeping him out of school. What we attempt to do is to issue an order where they can both remain at the same school. It obviously doesn't seem to be working, whether that's the school's fault or Mr. Grant's fault, I don't know. With this order, since it went effective, is he enrolled elsewhere?
I'm trying to get him enrolled because he just can't be missing school like this, so I'm trying to get
Exactly.
him a boundary exception.
Okay, so this order's been in effect since April 5th. That's time, I mean, you can typically do that in the next day.
Oh, we've already started, we have to get acceptance for it.
Well, they'll typically process that because they recognize, so something's not making sense to me. When did you go to the school?
No, I just went to a different, to get him enrolled in a new school, a whole new
What school?
Skyridge.
When did you physically go there?
Well, we couldn't do it, we had to get a boundary exception because it's not within the school that he went to by my
Okay.
house was not. a
You're not
school.
answering my question, thank you. At this point, I'm gonna grant the order, and we'll see what comes out of this unfolds in the criminal arena.
Thank you. I have a question.
Yes,
So I get paperwork, about somebody to investigate, and nobody's contacted me or his father about this.
you mean from law enforcement side? At some point in time, I'm sure they'll be contacting you. I can't tell you when, that's a different, I don't control law enforcement. I work with them and deal with the work that they do all the time in my position, but I don't direct when they're going to investigate, when they're gonna interview someone.
For clarification, do you want the minor person as the petitioner, or do you want her mother as the petitioner? I have several different things in the records.
Yeah,
And I don't know
she's
which
gonna
one's
be the
clear.
petitioner brought by mom.
Okay, thank you.
The one thing that I'll want you to understand in this, the order's good for 1 year. However, you can come in and seek to have this modified and changed, and where it could make some logical sense. I'm not saying it would be granted, I don't know what the circumstance would be then, would be at the end of the summer, if you're wishing to have him rolled back in Jefferson.
I think that he should just not go to that school anymore.
That's your
Yeah.
call, I'm just letting you
Yes.
know that even though this order's good for 1 year,
He'll be
Yeah.
out of the school by the end of this year anyways.
okay, that's this last year, so what's the next school he would naturally be going to?
As a high school,
Yeah,
I don't, we,
Skyview. Where are you planning on be attending?
Prairie High School.
Okay.
I work at Prairie High School, so we have to get a boundary exception. She wants to go over there, as a result of what has happened with her at Thomas Jefferson. But her home school would be Columbia River, if she doesn't get accepted to.
Okay, and so that wouldn't be a problem, Skyview, Columbia River.
Yeah, okay.
no, you were.
And your name again was?
Rochelle, York. Rochelle, R-A-S-H.
No, your last name?
York, Y-O-R-K.
finish processing you. Thank you. So they're gonna finish paperwork. Why don't you just go ahead and have a seat back here somewhere, and then they'll call you up. Thank you.
Your Honor, would it be possible to have the name of the person who's investigating so I can contact
I
him?
heard Detective Phelps.
Phelps, okay.
Monica Ellis, James Ellis, okay, well, is that?
He's 5'7".
Allison Middlebrook, Kelly Head, are you Kelly? Come on up. Let me take a moment and review the file.
It's at a friend's house. I lost it. I lost my backpack yesterday, so.
I'm sorry. What are you
The
telling me?
restraining order. I reviewed it briefly. I haven't had time since I worked so much, and to be honest.
Okay. All I said, sir, is hang on. I'm going to review the file so I know what.
Oh,
we're
I thought
all
you were
talking
asking me,
about.
sir. Sorry. Sorry.
All right, Mr. Head, so the question here is, she got a temporary protection order on April 8th. She's asking that that be continued. Do you have an objection to that? It would prevent her from you having contact with her or being at that party.
I have no problem with no contact. Quite honestly, Your Honor, I forgot her name because when you called the previous case, I thought that was her name. So I have no problem with like no contact. As a matter of fact, I had no intention of renting the room, but I made the mistake of inviting her to a so-called friend's house instead of like meeting at a neutral spot, so she couldn't like use my
Okay, well, what I've heard you say is you have no objection to the order, so.
No, sir. Absolutely none.
All right.
Your Honor,
Yes,
I'd like to make sure that Mr. Head understands that by not objecting to the order, he's not allowed back in the
I'm
apartment.
gonna go
Is that
over the
correct?
details of that. All right, Mr. Head, so you're to have no contact in any manner with her.
Is this lifetime? We can make it
It's for
lifetime.
1 year.
Okay, make it
And
lifetime.
then she can renew it if there's a problem with that. You're not to keep her under surveillance in any way, not to communicate in any way. You're to stay 500 feet from the residence or her place of employment. And the residence being the 7106 Northeast Hazelell Avenue, number 3, here in Vancouver, Washington. You'll each get a copy of this and step over here. The clerk will finish processing.
Your Honor, I have a clarification question. He has several belongings still in my apartment. It's a small apartment. There's
I'll
not
call
very
the
much
sheriff to
room.
come get him. Thank you.
The sheriff won't come and get them, so.
Or I got a third party to come get him.
And is that third party going to be in contact with me?
I'll have the sheriff call you.
They probably won't do that, sir, so let's talk about that.
Okay.
Do you have any problem with him having someone contact you on their behalf just to arrange the time to come and pick up the belongings?
I have no problem with that so long as he's not the one actually doing it. If it's a third party,
Right.
then that's fine.
Do you understand that, Mr. Head?
Yes, sir.
All right.
Is there a time frame in which that needs to happen?
It needs to happen fairly promptly, so I don't know what, hit that person's schedule and your schedule, how they're gonna match up. It should be occurring no later than the next week.
Okay.
That's fairly simple. Is it enough that could fit generally in a car?
Yeah, it should be enough. There's nothing like severely.
What I would do is have it all boxed, ready to go, placed by the door. And you know what time they're coming. If you wish to have a third party present, you can have them there.
Okay. Thank you, Your Honor.
All right, so you're gonna head downstairs and go, okay? They're gonna call you and get your copies.
Did we do on the 10 o'clock docket number 2?
Sign in, print and date.
Yes, Judge, that was his.
Okay, that's good. Joy Taylor, Michael Renz.
Thank you.
All right, we're gonna get someone on the phone on this.
Okay.
I'm assuming you're Michael Renz?
Yeah.
And you're Joy Taylor?
Correct.
All right, and you are,
The advocate for Casey.
okay. For Casey,
The daughter.
My daughter, our daughter.
okay. When you say advocate,
Well, she was her advocate.
I should say I was.
Correct, she was her advocate.
in what capacity?
The opacity of the child's concern about the abuse that.
Okay, what's the legal proceeding? I don't, I'm not sure.
Her fear of her father and.
Have you been appointed by any court order?
No.
Do you work for any agency?
I do.
What
I own
agency?
my own agency.
All right,
It's called the FAR.
and the
I've been
child
doing this
is
for
who?
like 20 years.
The child is, her name is Casey Renz.
And how old is Casey?
She's 9.
Okay. At this point, well, I'm gonna stand there. I'm not really having you participate in any manner. I'm not
Okay.
sure that there's any appropriateness of that. Well, I didn't tell her to leave either, but that's fine. All right, let me. You're represented in an issue by, let me find that name here, Craig Mason.
That's my attorney.
Oh, that's your attorney. All
And
right.
his attorney is in Spokane, Washington.
Pardon?
His attorney is.
I
in
know it.
Spokane. Okay.
Mr. Mason's asked that he be, he's appear on this
Okay.
for a hearing, so I'm gonna patch him in telephonically.
You got the number?
I have a number here. Yes, Mr. Mason, this is Judge Collier in Clark County. 1 second, I'm gonna patch you into our system. Mr. Mason, can you hear me?
Yes, Your Honor, thank you.
All right, we just called the case. We're here on the Clark County case. Mr. Rentz, who apparently you represent, is present. Joy Taylor is present, as well as an advocate. So, I understand there's also then proceedings taking place in Spokane that had to
Yes.
do
Oh,
around
sorry.
the parenting plan, and there's been recent contempt orders found. So.
Correct. And a restraint issued against Joy because of the way in which she took the child during Mike's time on March 29th.
All right, let me, just to make sure, I'm a little confused here, so I want, there's been some sort of parenting plan in place. I don't know if it came out of a dissolution action or parentage or how it,
Yes, Your Honor. The parties adopted a child jointly while cohabitating. It wasn't a romantic relationship, but they do have a child in common.
all
And
right.
then,
In
and
that
then,
order, in that
Sorry.
order, who's named as the primary residential parent?
they are 50-50 parents, Sunday to Sunday. Each is the custodian on their own time.
So we have this action here in Clark County. Mr. Renz, which county do you reside in?
Clark County now.
Ms. Taylor, where do you reside?
Clark County.
All right. So you're, okay, I was getting the impression maybe one of you was still in Spokane, but you're not. So,
I just moved over here
all
in
right.
December.
So the parenting plan that designated joint 50-50, 1 week for each of you, 1 week on, 1 week off, has that visitation schedule been modified?
I put in a request.
I'm gonna have you step up closer. I'm afraid
sorry.
Mr. Mason's not
Sure,
gonna
no
hear
problem.
you.
I put in my request
You
and we have.
put in, filed for a modification.
Correct, and we have court next on the 24th for the modification.
Okay.
Your Honor, when you have a moment, I can address that.
I'm sorry, speak directly into the phone. We're not hearing you right now, Mr. Mason.
Can you hear me now?
Yes.
Okay, yes, we have, the venue is still in Spokane County. It has not been changed, and we have a petition to modify set for May 8th. Ms. Taylor has filed one in Clark County with a hearing on April 24th.
Okay. So, I mean, at some point in time, a judicial officer in the family law is gonna have to determine which venue. And if you know, is it gonna be contested moving it out of Spokane?
Yes, Your Honor. Actually, we're moving to vacate the parenting plan because Joy had absconded to Vancouver with the child, and we did this because Mike wanted a peaceful resolution. And then when he moved down to take advantage of the 50-50, in our view, Joy has been trying to defeat the benefit of the bargain, and that's why the contempts. We also have another contempt set for May 8th. And so I'll also be moving to vacate based on her bad faith.
All right, the quiet right now is gonna be me looking at something in the file. All right, let's just set the stage here. What I have in front of me here today is a matter brought by Ms. Taylor for a protection order and claiming that there's been, with Mr. Rent's domestic violence towards the child. I see allegations of slapping the child.
Correct, that is what she has reported to me and a couple other witnesses as well. But I know we're not supposed to do that. We have to do a declaration, which one of their declarations is in my parenting plan modification that I did.
I was unable to hear that.
She basically acknowledged that, yes, the allegation is, as I said, that there was a slap, alleged slap of the child. She's working on getting some declarations about that.
Correct.
So we have a hearing coming up sooner in Clark County on Ms. Taylor's petition to modify the existing parenting plan, and we also have one in Spokane. And then there was recently contempt proceedings in Spokane. And if I understand right, Ms. Taylor, you were held in contempt?
I went to court last week for contempt. The reason I withheld my daughters is because of her safety and well-being.
All right, my
But
question
I know,
was-
yes, there was.
And
And then I don't know about this one in May 8th.
well, you maybe haven't been served yet.
Yeah, that one I don't know about. I mean, I got the paper, I know the court.
Stop.
Okay.
When I ask A, answer A.
Okay.
I'll give a chance. So last week you were held in contempt and violating the
Correct.
parenting plan. So really the question is, what do I do with this between now and the time that the family court, whether that's in Spokane or here in Clark County, can get their hands around this, their arms around it, to assess what's going on? Have you had a chance to read the petition in this matter, Mr. Mason?
Yes, Your Honor, and Ms. Taylor did appear in person on April 10th at the contempt and restraining order hearing, and as she had refused to file a written response, I allowed her oral testimony, which isn't normal here. It's usually on declarations, and she reiterated all of these allegations from the petition, and the commissioner did consider them at that time.
And did the commissioner there order that the visitation is to be resumed?
Correct, Your Honor. Mr. Renz is to get the child this Sunday at 6 p.m. Oh, no, last Sunday, and he got her. Sorry.
Okay, so the child, is that with you currently?
Well,
Kind of, sort of.
She has first right of refusal, and I work at night, so I had to work the last 2 nights, so I offered her to her, and then I will pick her up from school tomorrow.
Were you able to hear that, Mr. Mason?
Yes, he did. Joy did comply with the order beginning this past Sunday, and I would like to note that at the hearing on April 10th, she simply presented her position as one wanting a change to the parenting plan, and she did not really stick with any concerns of domestic violence. She did have a concern of suicide that the court gave her great leeway to present her view, and that is why in the order the makeup time is reserved for a substantive hearing for Ms. Taylor to present
Ms.
back.
Taylor, let me give you a little direction, and this is to aid the court, whether it's a judicial officer here in Clark County or a judicial officer up in Spokane County. So much of these become these kind of he said, she said scenarios. You have carried the burden of proof for your propositions that you're claiming. One of the things the court would expect to see are if the child is engaged in mental health counseling.
Well, I have, yes.
Stop, let me
Okay,
finish.
okay, that's fine.
Is a report, a letter, a report from the mental health provider that says, I'm just making stuff
I know,
up here as an
I know,
example.
you're fine.
I've been meeting with this child for the last 6 months, explaining what they think is going on, the mental status of the child, how severe is it, what do they think, and make recommendations as to if they come to this, and I'm not saying, sir, it is, that they have made a determination that there is an issue between her and father or her and mom, and what they're recommending, what sort of therapies, family counseling, individual counseling. That is not here at all. And it's the type of thing you're going to need, because if you're seeking to modify the existing parenting plan, the burden is on you to prove that there's been a substantial change of circumstances that would warrant changing. For example, if you're seeking in the situation, you being the primary parent. And how are we going to address these issues that you think are there? Because the goal is always by the court to have both parents being fully and actively involved and working towards that if it's reasonable and practical and doesn't place the child at risk physically, sexually, or emotionally. At this point, it really appears to be, with the level that I have here, that it's a family court matter, and that this protection order, and we already have a judge that had their hands on it here recently that reinstated the visitation, which is the family court that is currently hearing this case until it gets transferred to Clark County. What you're really going to need to, you filed this petition here, but you have an action in Spokane. Ms. Taylor, what you're really going to need to do is file a motion in Spokane County asking to transfer the venue. Now, you do have, I would think, some things in support of that. Both of you reside here.
Correct.
It's not practical for you both to be going up to Spokane County every time you need assistance of the court.
Correct.
But I think you should be making that motion to Spokane County to transfer venue.
Okay, I have a question though.
Yes.
Okay, because I did call the Clark County and I called Spokane County, and they just told me all I needed to do was to modify my parenting plan, which I put in the request and it's in the court system. And these 3 documents, one of them is the final parenting plan.
Right, but you're missing the point.
Okay.
I'm trying to make. There is an existing court order. I mean, we don't have it where you move to Clark County, you file in Clark County, then 2 months later you decide you're gonna move to King County and you file there. They have ongoing jurisdiction, Spokane County. You've got to request that they decline that and that it makes more reasonable sense under the facts of the case today to be transferred venue to Clark County.
Okay.
Because, and your primary is gonna be that both of you now live here. It doesn't make sense.
Correct.
I'm not saying that how that judge or judicial officer is gonna rule, that's gonna carry a lot of weight. But just because you file it here doesn't automatically give it here. Our court, whoever you're gonna be in front of, is gonna say, well, because here's what could happen. Clark County says, yeah, we'll handle it now. But then Spokane County still has it. What if they're given inconsistent orders? What does law enforcement know what to do? What do schools know what to do? So you gotta figure out which court's gonna handle this. Spokane County has it at this time until they release it. You need to file a motion for change of venue
Okay, and I have the forms to do that.
in Spokane County.
Okay, yeah, I have those forms, I got them when I was in court
But
last
at this
week.
point, based on what I see here in the file and I hear, and this is actively in front of 2 courts at this time, I'm gonna deny this order because it would be inconsistent with what was just ordered by a judge in Spokane, and I don't find a basis to make that inconsistency. They have more jurisdiction with regards to the child. The case is actively in front of them. They've been actively and just recently hearing it.
Excuse me, Judge, can I say something about Casey?
And you are,
I'm Samantha.
and your connection to this?
I am a witness to what Casey has said.
Thank you. Please have a seat. Thank you. Please have a seat. Thank you. Please have a seat.
I can't sit anymore
Then,
because I have an injury.
okay, step out of this area back into the audience area. You are not a party to this. Step back.
All right, I'm standing.
No, you're not stepping back to the area I asked you to step back in. Thank you. I'm not going to require that you sit.
Hello?
Yes.
Oh, I'm sorry, Your Honor. I thought I
I'm
lost.
filling out an order here that's dismissing this protection order and leaving this matter in the family courts, and at this time, Spokane County until it gets transferred venue to Clark County if that should occur.
Thank you, Your Honor.
All right, I've signed that order. You'll need to get this, you'll be back in Spokane County. You really need, Ms. Taylor, to get your motion for change of venue in Spokane County.
Correct, and I
going
have
right
the
away.
forms, because originally I was told I didn't have to, and then now I'm being told I have to, so that's, I got the
Well, you can
forms.
file your action here in Clark
Yeah.
County and kind of to get things process started, but ultimately, Clark County isn't gonna be able to take this until Spokane, or Mr. Renz consents. If, Mr. Renz, if you're saying that you believe it ought to be handled down here in
No, I
Clark.
want to stay in Spokane.
All right, and that'll be decided up there. You know, I think, Ms. Taylor, you have a very good chance of getting it transferred down here because it doesn't make sense when the child and both parents live in this county to continue in Spokane. But
Okay.
that's for them. And
Okay.
sometimes courts will do similar to what we call a UCCJEA, Uniform Child Custody Jurisdiction Enforcement Act. This isn't a jurisdictional question, it's a venue question.
Okay.
Where the two judges in each county will converse.
Okay.
That happens frequently when you trying to do an action in another state, but even though it doesn't directly apply here, kind of by analogy, it's not uncommon to occur.
Okay.
So,
When you do the jurisdiction, the
It's-
venue, sorry,
Venue.
the venue, that's what I mean. Is it possible that I can wait until I have to go there like in 2 weeks?
I'm not telling you, I'm just
Okay.
suggesting you need to get it there.
Okay.
You're gonna have to file it, get service on at least a week before
Okay.
the hearing. So
Okay.
about 2 weeks is really about the fastest you could
Okay.
probably do it.
Okay. Well, it's because I just don't live in Spokane, so that's
No,
what I
I
was curious.
understand that, and that's why neither of you live there anymore. But at
Correct.
this point, that's for the Spokane court to be involved in. I think with that matter, we are done. All right.
Thank you
Mr.
very much,
Mason,
Your Honor.
with that, I'm gonna terminate your connection with us.
So did you need to see your safety plan?
No.
Okay.
All right, thank you, Mr. Mason.
Thank you, Your Honor.
Bye-bye. All right, you're free to go, sir.
I don't need to
Or-
sign anything.
Wait, step over, step
Okay.
over here, go ahead. We'll move to the Richard Dixon, Paul Jones matter. Richard Dixon, not present. We're now almost 3 hours into this. I'm gonna get Mr. Jones on the phone because he had requested. Well, let's see what call him and get him on the phone. Yeah, feel free to have a seat, sir. That's not a bad idea.
I just don't want any
Yeah,
complications.
no, I agree. Just have a seat back in the audience area. Yes. Poe Jones. All right, one second. This is Scott Collier, the judge in Clark County, Washington. I'm going to patch you into our system. One moment, please. Ms. Jones, can you hear me?
Yes, sir.
All right, one second. The quiet's going to be me taking a look at the file. Something's not making sense to me.
Okay.
Probably just, anyway, hang on one moment.
Okay.
I should let you know we called the case. Mr. Dixon is not here.
Okay.
All right, so what happened is he petitioned for the protection order. It was denied, and then it was set for a hearing today.
Right.
He's not here. It's going to just be totally dismissed today.
Okay.
So with that, I'm just going to do the paperwork. I'm going to go ahead and hang up with you. You can be aware that this action case has been totally dismissed. And
Okay.
all right, so thank you.
Thank you for your time.
Bye-bye.